Mr. Kohberger, do you understand the charge in count one?
Yes.
A hearing in Bryan Kohberger's case this week is shrouded in secrecy as his legal team asks the judge to throw out the indictment, charging him with the murders of 4 University of Idaho students.
I would say this is more than, a really big hill for them to climb. This is like Mount Everest they're trying to climb here.
Thanks for joining us here on Law and Crime. I'm Angenette Levy. Bryan Kohberger's lawyers have filed 2 motions asking Judge John Judge to either dismiss the indictment against him or to send the case back to a lower court for a preliminary hearing. In a preliminary hearing, a prosecutor calls witnesses, think detectives or crime lab analysts or even eyewitnesses, to show a judge there's probable cause that a defendant committed a crime. Defense attorneys like preliminary hearings because they get to cross-examine witnesses before trial, and sometimes they learn information that can help the defense. That didn't happen in this case. Instead, the Latah County prosecutor chose to present the case to a grand jury, which is done behind closed doors without Kohberger or his lawyer present.
I knew from the get-go that this was almost assuredly going to be a case that was brought before the grand jury.
Edwina Elcox is a criminal defense attorney in Idaho who's following Kohberger's case. She explained why it wasn't surprising that a grand jury was impaneled.
You have a large amount of media speculation and public speculation about the case. You have the victims' families, and also the other roommates that were there and other potential witnesses in the case. And so I think to protect the integrity of the proceeding, the grand jury was almost assuredly the route the prosecution was going to take. Now, absolutely, do I understand why the defense would have preferred the preliminary hearing route, right? You get the first shot at the state's witnesses and the evidence, and the state doesn't get to solely control that narrative. But I do not think that it is surprising at all that the prosecution elected to utilize the grand jury.
Kohberger claims the grand jury was biased and that the grand jury heard inadmissible evidence. Kohberger also claims the indictment should be dismissed or he should get a preliminary hearing because of prosecutorial misconduct.
I think if there's any area where there would be a solid or a theoretical solid challenge, it would be the impaneling of the grand jury, right? We have a very, very small community, a small county. And so obviously when you have a case of this magnitude with not only national attention, but international attention, it would be very, very hard to seat a jury locally that had no preconceived notions or frankly hadn't heard about the case at all.
Kohberger did not enter a plea at his arraignment in May.
Your Honor, we will be standing silent.
Because Mr. Kohberger is standing silent, I'm going to enter not guilty pleas on each charge.
Kohberger's attorney Ann Taylor said he stood silent to preserve his right to challenge the indictment. But the information the defense is using to support their claims is sealed. A hearing on that motion is closed to the public this Thursday, an incredibly rare occurrence in a criminal case. So what could possibly happen at that hearing?
I would imagine that there is going to be evidence presented, whether that is through documentary evidence, witnesses, and live testimony, right? But when you have a motion of this nature, it's not something that the defense can just theorize about, right? To make this argument and to ask the court to make the ruling to ultimately dismiss the indictment in this case, it can't be theoreticals and it can't be hypotheticals. I would imagine that the defense has to have some real concrete evidence to show this is what happened, Judge, or these series of things are what happened. And this is why this indictment cannot stand. I mean, this in my mind is not a case this motion is not a situation where it can just be legal theory and argument. You're going to have to present to the judge some absolute concrete evidence testimony and otherwise to convince the judge there is something that occurred that warrants the dismissal that the defense is seeking in this case.
Police have cited circumstantial evidence, such as touch DNA and cell phone records, in making the case that Kohberger murdered students Kaylee Goncalves, Maddie Mogen, Ethan Chapin, and Xana Kernodle nearly 1 year ago. Kohberger's second motion to dismiss the indictment claims prosecutors did not present enough evidence to grand jurors. They cite the Idaho Constitution that says the grand jury ought to find an indictment when all the evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. That's different from the probable cause standard currently used. Idaho attorney Tara Malik on that argument.
What the defense has been arguing here is that the same standard that's used at trial to convict someone, so beyond a reasonable doubt, should be used at the grand jury stage as well. Both in a preliminary hearing route, had the state gone that way, or in the grand jury proceeding, the standard has been under modern jurisprudence, this probable cause, more likely than not, 51% standard that a crime was committed and this individual is the one that committed the crime. And so for the defense to come in and argue now that we should throw all of that out, all of these courts who've interpreted this statute as it comes to the standard of proof are wrong, and we need to go back to, or we need to go to this high beyond a reasonable doubt burden is not a novel argument, but one that has been pretty soundly rejected by the courts.
Is this a case of the defense literally doing everything they can to challenge this case? Because, I mean, maybe the legislature needs to go back, or the voters of the state need to go back and amend this part of the Idaho Constitution. But it just seems to me this is not going to be an argument that flies, although I give them points for creativity.
Yeah, I mean, I think the defense is in a really tough spot with this case. What we know so far, and admittedly, we haven't seen everything. We're not privy to the discovery that's gone back and forth between the state and the defense team here. But what we've seen and what we know so far presents a pretty compelling picture and a pretty compelling theory of the case that the state has here against Bryan Kohberger. And so I'm sure that the defense is looking at every route and really holding the state to its standard of proof, as well as making sure that the state has followed all the rules that it needs to follow. But I would say this is more than, a really big hill for them to climb. This is like Mount Everest they're trying to climb here with this legal argument.
Bryan Kohberger remains in the Latah County Jail, where he's held without bail. Law&Crime will bring you the public portion of Thursday's motion hearing on our YouTube channel, so stay tuned. For Law&Crime, I'm Angenette Levy.